So maybe when it comes to legal, we can dive into the actionable steps. For example, for organizations, like a compliance checklist today, if someone wants to take the steps, what are the steps required?
Well, thank you so much. This is, of course, to back up the fact that registration itself is not enough. So what's enough? What is required? What more steps? What should organizations do? Well, the law provides for vast obligations that the organizations can put in place, can respect to make sure personal data they deal with is protected. And of course, registration is a key because there you are recognized as someone who processes personal data, either on their behalf as data controllers or on behalf of data controllers as data processors. And next, the law also talks about appointing or designating a data protection officer. Organizations should have a data protection officer who leads the implementation of this culture, of this law within their organizations, but also who act as contact person between the organization and the supervisory authority, or else even the organization and even the data subjects, because data subjects have the rights that they're entitled to, that they should exercise, and the contact person in that context should be the data protection officer. And also the law bridges data controllers and data processors to maintain the records of processing. Imagine you processed some data some time ago and you can't trace it now.
I see. Yeah.
It's really risky. And in the inspection and assessments we do, we need to know the processing history, what you collected, what you shared, what you deleted, what you analyzed, all the decision making you got from the data, and we need to know the details. So if you don't maintain those data, then you can't protect what you don't know, what you don't actually have. Next, reasonably, as my colleague has been saying, when the organization transfers or stores personal data outside of Rwanda, the law puts another obligation of authorization from the authority. Well, when it comes to transfer, there are other options like consent of the data subject or necessity as is described in the law, but there's also authorization from the supervisory authority after showing the appropriate safeguards that data is going to be safe where it has gone. And specifically on the storage, outside storage, it's a must. When there is outside storage of personal data, the controller or processor in question should seek authorization from the authority beforehand. And also security. The law bridges the data controllers and processors to implement both organizational and technical security measures to make sure the data they process is safe. And the law also attaches much more safeguards when the institution is processing sensitive personal data. When, of course, the law defines what sensitive personal data means. These data related to our social origin, our biometrical, genetical information, our health status, as my colleague has been establishing, the religious and philosophical beliefs, the political opinion, the family details, the medical records. The law has the list.
Yes.
So those sensitive data should have additional safeguards while protecting them, because violating them poses a higher risk to the data subject. And also the law talks about when it comes to the obligations, maybe my colleague can jump in and probably if he remembers something else. But the law reasonably recognizes that there can be partnerships in data processing. You may engage some other organization to process on your behalf. And if that's the case, then there should be data processing agreement between you, the data controller, and the processor who is processing on your behalf, for them to feel the obligation of safeguarding that data as you can safeguard it yourself, or even as a data subject can safeguard it themselves. Yeah, so the law provides for, it's more like a culture.
Yeah.
It's a continuous assessment that should be carried out internally by the organization to make sure each and every, also the law talks about observing data protection principles. My colleague talked a little about it, but the law provides for data protection principles to be observed while processing personal information. And among them, there is lawfulness, transparency, and fairness. When you're processing personal information, you should observe that. You are processing lawfully, you're transparent, communication between the one processing the information and the data subject, and also fairly. It doesn't pose a threat or to the data subject. And also the law talks about another principle of purpose limitation. Why are you processing data? There should be a specific purpose as to why you're collecting data from the data subject. What are you using it for? There should be, you can't process anyhow.
Yeah.
For any reason. There should be a specific purpose in the first place before you even get the data from the data subject. And also data minimization. If we have a purpose already, why don't we collect only the data needed for us to achieve that purpose? As you've been mentioning on statements that might seem noisy or necessary, it wouldn't be necessary. If it is not necessary, then there's no need to collect it, because you should minimize data only to achieve the purpose that you collected data for. Another one is accuracy. You've been talking about it. Data should be accurate. That's why the law provides for the right to rectification. Data must be accurate and must be rectified if it is changed for updates. And also the law also talks about storage limitation. Why do you keep this data longer than necessary? Why? If the purpose ceases to exist and there's no any other purpose or no legal obligation for you to keep that data, there's no need to keep it anymore. And also accountability, should be accountable for the safety of the data. The last one would be observing data subject's rights. That's an obligation. What I'm talking about is something beyond registration that institutions should do to make sure this data is safe. Data subjects under the law are entitled to some rights on their data. And among others, there is a right to access their data. An institution is processing your data. Maybe you're an employee of the institution and they're processing on the purposes of HR management, let's say, for example, or the execution of an employment contract. And you want a copy of your data they have.
You're allowed to receive it.
You're allowed to write to them and say, hey, I want a copy of the data, personal information you have for me, and they are obliged actually to provide that data because you have the right to access. Also, if your data is it has changed, let's say your ID has changed, you know, when you misplace your ID and you request for another one, some digits change. Those institutions that are processing that ID need to update according to the new ID. So you can write to the institutions and say, hey, my ID is no longer the other one you have.
Please update.
Please update. This is not mine. Okay. Mine is this. So you have that right. And also portability, very important. You have the right to request the institution, the data controller or data processor to transfer your data where you want it. For example, you are changing employment, let's say, for example. Do you need to go reintroduce yourself to a new employer when you had an existing employer who has all the information? You have the right to write to the previous employer to transfer your data to the new employer for you to go when the information is already there. You don't repeat. That's your right. Also erasure, though not absolute, but erasure also is a right of the data subject entitled to by the law.
Yeah.
You don't need your data to be processed anymore. You want them to be deleted. Well, there's a right to object processing, but also the right to erasure. They can keep the data, but do not process it some other ways. Maybe they keep with it, but they do not transfer. That is objective processing. But erasure is total deletion. If there is no legal obligation to keep that data any longer, and you no longer want that data to be processed, you can request the institution in question to delete your data. So data controllers and data processors have the obligation to put in place the procedures to make sure data subjects' rights are realized and respected. They have actually 30 days to respond to those requests if made. If they don't, or they do not reply accordingly, then the data subject has the right to lodge an appeal before the supervisory authority, which is National Cybersecurity Authority Data Protection Office, for redress. I guess I can summarize it in that way.
Okay.
Maybe my colleague would add something if it's there, but it's really beyond registration.
Yes.
It's a commitment, it's accountability.
It's a responsibility
it's
for everyone.
Responsibility
Yeah.
for everyone to keep tracking, is this data safe? Are data subjects' rights respected? Are we really doing well when it comes to our obligations in the law?
Yeah.
So it's a continuous process. It's not just one-time act.